Right, I think we'll get started now. I don't want to keep you much longer than I need to for today. Thank you very much for joining me today on this rather sunny Friday afternoon. Today's webinar will be discussing the enforcement of child arrangements orders. The webinar is going to be recorded, and the webinar recording and the slides that I use today will all be made available on the Goldsmith Chambers website, and I'll email you after today to confirm where you can access those and how you can download them if you need a copy. There will hopefully be time at the end of today's webinar for you to raise any questions that come up and for me to do my best to answer them. I'd suggest using the Q&A function if you do have any questions that you'd like to raise, and I can have a look at those towards the end of the webinar. So let me start off by looking at the making of an application and the procedure, and then I'll move on to a question of reasonableness in terms of, and equally the question of breach of the order itself. It's worth noting that an enforcement order, unlike some other orders, can only be made in response to an application. The court can't make an enforcement order of its own volition. So where you have a party who is concerned about the compliance with an order, then really an application should be made because the court otherwise wouldn't be able to make an order. An enforcement order should be made on an application form C79. That form covers both an application for an enforcement order and also an application for an order for financial compensation. I'll come on to an order for financial compensation in due course in this webinar. You'll note an application for committal for breach of an order is made under a separate procedure. That's the Part 18 procedure, and really that application will be seen as an application of last resort. You should really be looking to an application for enforcement before you're looking at an application for committal, and there are different considerations that the court will need to look to before it will make an application for committal. An application for an enforcement order needs to be accompanied by the appropriate fee. That's currently £125, or a fee exemption form. You'll need to attach a copy of the order that you are asking the court to enforce, and you'll need to ensure that the application is filed with sufficient copies so that the respondent or respondents can be served, as well as CAFCAS being served with a copy of the application and any supporting documents. The application, once issued, should be served with sufficient time for the respondent to file a response within 14 days of being served, and certainly not less than 14 days before the hearing. The court, in an ideal world, will list an application for enforcement order within 20 days of being issued. That certainly was the guidance before COVID-19, and unfortunately there are likely to be delays in the court's capacity to list any applications given the current circumstances. There is in any event an emphasis on the court conducting without delay and concluding without delay applications for enforcement orders because of the very nature of the order that you're seeking to enforce. Wherever possible, and ideally, an application for an enforcement order should be allocated to the judge previously allocated when the original child arrangements order was made. When considering the application, the court will be looking to a number of factors. First and foremost is going to be whether or not the factual basis alleged for the non-compliance is agreed. Where it's not agreed, the court will need to list the matter for a hearing so that it can establish the factual basis of the non-compliance. The court will also want to have an idea of any reasons that the respondent is seeking to advance for the non-compliance, and the court will want to have some consideration for the wishes and feelings of the child and how those can be ascertained, whether there is any need for advice from CAFCAS, the risks that may well arise or may be apparent in making either a further child arrangements order or indeed a variation of the current order, and also whether there is a need for any safeguarding checks Certainly where an order was made more than 3 months after 3 months before the application for an enforcement order, it's more than likely that the court is going to order safeguarding checks to be provided. Certainly one of the things that it is advisable to consider before making an application for an enforcement order is whether the child arrangements order you're seeking to enforce is in fact enforceable. That is, does that order have attached to it a warning notice, giving a clear indication to the parties about the consequences if they were to fail to comply with that order? The court must ordinarily attach a warning notice to a child arrangements order whenever one is made or varied, but certainly where there are child arrangements orders made pre-December 2008, there may well be no warning notice attached to the child arrangements order. And in orders made pre-April 2014, the warning notice might only be attached to the contact provisions within the child arrangements order and not the residence provisions within the child arrangements order. So you need to be sure that there is a warning notice that is attached to the appropriate parts of the order that you are seeking to enforce. If the warning notice isn't attached to the order that you're seeking to enforce, you'll need to make an application for the order to be varied so that the warning notice is attached to the order. You'll need to make sure that the other party or parties are made aware of that warning notice. So before any alleged breaches of that order can then be brought before the court for enforcement. It's also worth considering whether or not and to what extent the terms of the child arrangements order that you're seeking to enforce are sufficiently clear. You'll see further on into this webinar that certainly one of the considerations for the court and the powers that the court has is where it's faced with an application for enforcement, it may ask itself whether the engagement and compliance of a party can be sufficiently secured by a rephrasing or variation of the order. And I've certainly seen cases where it's alleged a party has failed to comply with an order, but there has been a fundamental misunderstanding between the parties about certain terms in the order. For example, what the meaning of 7 days is. Should it be counted on day 1 or should it be counted as 7 clear days? Small details like that make it a consideration for the court as to whether or not, in fact, an enforcement order is necessary, or whether actually the issue can be better and more adequately dealt with by clarifying and varying the child arrangements order itself. The respondent must be over the age of 18 and habitually resident in England or Wales for an enforcement order to be enforceable against them. So certainly before engaging in the process, it's worth checking that before you make the application, and also that the child arrangements order must not be an accepted order. So when can the court make an order for, when can the court make an enforcement order? The court needs to be satisfied of a number of things before it can make an enforcement order. First, and I touched on this earlier, is that the court needs to be satisfied that the failure to comply with the child arrangements order occurred after a party, so the respondent party, was made aware of the terms of the warning notice and the consequences for failing to comply with the order. It's for that very reason that it's very important that you make sure, before you make the application for an enforcement order, that the order does in fact have that warning notice attached to it. The court must be satisfied beyond all reasonable doubt that the respondent has failed to comply with the child arrangements order. I've underlined beyond all reasonable doubt because that's the criminal standard of proof. So a much higher burden on the individual making an application for an enforcement order. I've touched on this already, but the court also needs to be satisfied that an enforcement order is necessary to secure a person's compliance. As already indicated, it may well be that the court can find that an individual has failed to comply with an order, but may say that actually there are less onerous steps that can be taken to secure that person's compliance with the order. The court must be sure and satisfied that the effect on the respondent party of the proposed enforcement order is proportionate to the seriousness of the breach. Remember, we're talking here about securing a person's compliance, and it needs to be that the court has the sufficient powers, sufficient bite to ensure that that compliance is effected. CAFCAS will ordinarily obtain information from the respondent about the likely impact of the proposed enforcement order, an enforcement order being an order for unpaid work. So where CAFCAS is looking at information about the impact, it will look to the respondent's circumstances, their childcare obligations, work obligations, any vulnerabilities that they may have, any religious considerations that need to be taken into account, so that the effect of any proposed enforcement order can be fully evaluated. The other consideration is also that the enforcement order can in fact be made in the area where the respondent resides. If it can't be made within that area, then the order is not going to be effective. Lastly, you'll see that the court must take into account the welfare of the child. Ordinarily, you'd expect that if a parent, the resident parent, is now going to find themselves having to undertake additional unpaid work, their availability to the child is going to be reduced. That said, the welfare of the child is not going to be the paramount consideration when the court is looking at making an enforcement order. Does the respondent have a reasonable excuse? And this is arguably stage 2 in a 2-stage test. The first stage being this provision here, whether the court is satisfied beyond all reasonable doubt that the respondent has failed to comply with the order. And the court should treat this as a 2-stage test. It should first be satisfied that there is in fact a failure to comply, and then turn its mind to whether or not the respondent has a reasonable excuse for failing to comply with the order. You'll note here that I've underlined that this is on the balance of probabilities, so it's on the civil standard, not the criminal standard, when the court is considering it, and the burden is on the individual who's seeking to rely on that reasonable excuse to present it to the balance within the balance of probabilities. In terms of examples of where the court might deem an excuse to be reasonable, the Court of Appeal has recently given an indication, for example, of a child being ill, a parent being expected to make that child available for contact, and the parent instead taking the child to a doctor or hospital instead of taking them to contact. The court has indicated that that may well be a reasonable excuse in the circumstances. When looking at a reasonable excuse, the court may ask itself a series of questions along the lines of whether or not the parent, what was the parent required to do? The court will have to look at the order and what the parent was required to do within the terms of the order. And that's why it's so important that the part of the order that you're seeking to enforce is sufficiently clear. Once the court has ascertained what the parent was expected to do, well, then the court will ask itself whether the parent could do that thing. So if a parent is expected to make a child available for contact, can the parent do that? If the parent could do that but didn't do that, then the question is why? What is the reason that they say they were unable to do that? And is that reason sufficient to be a reasonable excuse? I appreciate that many of you may well already have had clients contacting you to ask about the enforcement of orders during this COVID-19 health crisis, and you may well end up still receiving questions about the enforcement of orders given the current circumstances. The family courts have issued guidance on the 24th of March, and you may well have read through that already. But really, the key message to take from that is the court is saying where the restrictions arising from coronavirus cause a court order to have to be varied, the spirit of the order should nevertheless be followed, and parents should be looking to make alternative arrangements so that contact with a child is not lost. The court wants parents to communicate with each other. The court wants it to be a sensible discussion where the risk and assessment of the circumstances are considered when the parents are looking at alternative ways for contact to continue during the current restrictions and certainly during the current health crisis. Within that guidance, the court has stressed that the courts expect alternative arrangements to be made so that contact can continue to be regular, and certainly the court has given an indication, and a strong indication, towards video contact being facilitated either through Skype, Zoom, FaceTime or WhatsApp. And where that's not possible, then for telephone contact to take place instead. You'll note on the first bullet point, the underlying provisions there is that where a parent makes a unilateral decision to withhold contact or to stop contact altogether, and the court is being asked to look at whether or not a parent has acted reasonably, so a reasonable excuse, the court will look at the official guidance that's in place at the time, the rules or the stay-at-home rules and what they look like at the time, and any specific evidence relating to the child and the family. So where you're looking at COVID-19 and the reasonableness of an excuse, it needs to be taken in a much wider context, and the court will be looking at the stay-at-home rules, any Public Health England guidance, any vulnerabilities in the home, and other matters that bring a much wider circumstance into consideration. And where parties are looking at the viability of alternative contact methods, and certainly the reasonableness of those methods, the court may well be looking to whether or not, to the very nature of the contact which the parties are seeking to find alternative measures for. Certainly if contact under the child arrangements order was meant to be supervised or supported, well, there has to be consideration to how much that can be facilitated over video contact and how safely that can be facilitated over video contact. Certainly in the early stages of the stay-at-home rules and the restrictions on outside time, there was no scope or very little scope for any contact to take place outside in the community. We are seeing a gradual loosening of the rules, and at some point there may well be permission and it may well be permissible to have contact out in the community again. But until that happens, where contact is supervised or supported, it may be that video contact is not appropriate. Equally, consideration needs to be given to the resources available to each parent. For example, the ease at which and the safety at which parents can travel between houses, the devices parents have access to. Not all parents will have access to phones, tablets or laptops, so it may well be that they can't facilitate video contact because they just don't have the device to be able to do so. And equally, they may have very limited or very unreliable access to internet, so video contact may not be possible. It's also important to look at the vulnerability of a party, for example, where there are issues or concerns about domestic abuse, where there are health considerations which make certain recommendations for contact unsafe, and also where there may well be a non-molestation order in place, which means that video contact can't be facilitated or telephone contact can't be facilitated. These are all things that need to be borne in mind when looking at the reasonableness of a party's actions. So the powers available to the court where a breach has been found, and I say that a breach has been found and the court has not found that there is a reasonable excuse for that breach. I touched earlier on the court having powers to put in place measures that are arguably lesser measures or less extreme measures than an enforcement order. Indications of that are, for example, a referral to an SPIP or mediation, and it may well be that CAFCAS has found that actually this might be the most beneficial and the most suitable measure to ensure compliance with the order. Again, as I indicated earlier, you may well the court may well deem that a variation of the order or a clarification of the order is sufficient to ensure compliance with it. It may be that actually an enforcement order is not necessary because the lack of compliance has arisen as a result of a misunderstanding of the terms of the order itself. You'll see that I've put in brackets reconsideration of residence provision in very exceptional circumstances only, and really that's the point. The court can, in very, very exceptional, very rare cases, make an order transferring residence from the resident parent to the non-resident parent, really, when absolutely everything else has been tried and it's been unsuccessful. And I stress the very exceptional nature of that being an order the court may seek to make. The court may well make an enforcement order, and it may well be that that order is suspended. The court may feel that the threat of an enforcement order is sufficient to ensure compliance, and then the court may make, in addition to any enforcement order or in place of an enforcement order, an order for compensation for financial loss, and I'll touch on that in a moment. You'll see at the very bottom of this slide mention of committal for contempt of court and a fine. Well, these again are measures that are generally regarded as remedies of very, very last resort. The court will ordinarily have made attempts to secure compliance through suitable referrals, through variations of the order, through enforcement orders, through other means before it's going to look at a committal. And certainly when it is looking at committal, it may well be that committal just for 1 or 2 days is enough to really send the message home. So important to note that committal really is a remedy of last resort. Equally important to note that where an application has been made for an enforcement order, the court would not ordinarily be looking at committal. It would be looking at committal where, for example, the enforcement order has been breached. Just some additional information and provisions about enforcement orders more generally. As I said earlier, an enforcement order is an order imposing a requirement to undertake unpaid work. The order may be suspended for such period as the court thinks fit. It may well be that the court suspends it for 5, 10, 15 years, although that would be unusual. The court can make more than one enforcement order in relation to the same person. So it may be that the court finds that there have been multiple breaches of the child arrangements order, that there's no reasonable excuse for those breaches, and the court makes an enforcement order in respect of each of the breaches or each of the provisions for that person on that same occasion. As with the child arrangements order, the court must attach a warning notice to the enforcement order, warning of the consequences of the non-compliance of the enforcement order. CAFCAS will be the body responsible for monitoring compliance with the order, and the court will ask CAFCAS to report on that individual's compliance with the order. As I said, I touch on compensation for financial loss. This is an order that the court can make alongside, in place of, or in addition to an enforcement order. You'll see it has the same requirements, that the court needs to find that the respondent has failed without a reasonable excuse to comply with a child arrangements order, but the court also needs to be satisfied that the applicant party has suffered financial loss by reason of that breach. It's important to note that a compensation order is not a punitive order, it is a compensation order. So the court will only make an order for any amounts that it finds a party has lost as a result of the breach of the order. Some examples might be, for example, the costs arising in a holiday that couldn't be refunded or moved, travel costs where contact didn't take place, the cost of a contact centre where contact didn't take place, all examples of the types of compensation that individuals may seek to wish to seek an order for. There is provision within the C79 form to say that you or a party intends to make an application for compensation for financial loss, and certainly if you are intending to make an application for compensation, that will need to be supported with evidence, so receipts and any other supporting evidence that you might have. Lastly, and this is just a point to note, the cost provisions where there is an application for enforcement don't carry the usual presumption that you find in child arrangement proceedings, that there is a no order for costs, and the court does have the discretion to make costs under CPR Rule 44.3. I'm now going to open up the floor for any questions. So please do use your Q&A function, and I will do my very best to answer any questions that come in. So I've seen a question come in: if breach is found, could an order for costs be granted along with financial loss and or variation, etc.? Well, arguably yes. A cost order would be separate from the enforcement order or any other orders the court would make. As I've touched on at the very end of this webinar, the court does have the discretion to make an order for costs. An order for financial loss would be your compensation order. That is an order of its own type, and therefore the court could make that order separate to an order for costs, because it is an order for compensation for loss as opposed to costs incurred in making the application. And or an order for variation. Well, as I've said, if the court feels or deems that the most appropriate way to secure the engagement of a party with a child arrangements order is by making the variation, well, then the court may well make that order for variation, in addition to recognising that a party has suffered a loss, and therefore make an order for compensation. I can see a question here about the enforcement of a protective order. Can I just clarify, when you say protective order, are you talking about a non-molestation order? And I'll just wait for a response to that. If it is an application, I mean, if we are talking about a protective order by way of a non-molestation order, then it is a different process that you would be following. You wouldn't be following the enforcement order process. The enforcement process that I've discussed or touched on today is the process which you would use for a child arrangements order. Before I finish, there's just one more question. If the respondent fails to comply with a child arrangements order, would the applicant need to send a warning letter before issuing a claim for an enforcement order? Well, really, if the outcome that you're seeking is to say, right, we need to find a way to make this work, it may well be that you find that the parties might be one of those cases where there is a misunderstanding about the terms. So if it's going to assist the parties by writing to them in advance to say, look, we have these concerns, what is the reason for non-compliance? Do we need to make an application to vary, or do we need to vary this order? Do you understand this order appropriately? Then that may well be a way of avoiding the need to issue enforcement proceedings. If you feel that that is not going to get you much further, then it may well be appropriate to issue an application for enforcement, so that any delays in contact and any cessation in contact is not going to be extended unnecessarily. Right, I think that looks like all of the questions that are going to come in for now. Obviously, if there are any other questions that I didn't have a chance to get round to, by all means, please send an email to my clerk and she'll be able to direct it to me, and I will do my very best to address it. Thank you again very much for dialing in today on a lovely sunny Friday afternoon. As I said, the slides and a copy of this recording will be made available on the Goldsmiths Chambers website, and I will circulate information for how you would be able to access that and download them in due course. So thank you very much, and I hope you enjoy the rest of your weekend.